Restraining orders in Indiana. Most common questions answered. A lot of people know a restraining order to be an order issued by a court where you're not allowed to be around or contact a certain person. In Indiana, these are called protective orders, and they're civil in nature rather than criminal.
What should I do if someone files a protective order against me in Indiana?
So commonly, what will happen if someone files a protective order against you is that you'll be served either personally or by the mail. And what that means is a sheriff could either come to your house with the protective order issued by the court and serve it to you, or they may mail it to you via certified mail, and you may just receive it in a mailbox one day showing that someone has requested a protective order against you, and that judge has either set it for a hearing or has granted it already, which is called an ex parte granting of a protective order. If a judge issues an ex parte restraining order, what that means is based on the allegations alone, the judge has determined that there is a need for a restraining order right here and right now, and that means that that restraining order goes into effect immediately as soon as you either receive it in the mail or a sheriff's department, someone brings it to you personally.
How do I respond to a protective order in Indiana?
So say you've been served with a protective order and you're wondering, what can I do about this? How can I respond? Well, the easiest way is to hire an attorney. What an attorney can do is enter an appearance on your behalf and ask that the court set the protective order for a hearing. Now, if this was a non-ex parte protective order, it probably has already been set for a hearing, and you would have received information on that hearing on the notice of protective order that you either received from the sheriff's department or got in the mail. It usually will have a court date and time, and that's when you can go to court to fight against that protective order. Now, even if it's already set for a hearing, it's always very important that you have a lawyer to be there with you to assist you in defending against that protective order hearing. Now, if the protective order was granted ex parte, meaning it's already in order, then the timeline gets very thin. There's not going to be a hearing date set because it's already in effect. But what you can do is ask the court to set a hearing, but that request must be made within 30 days of the issuance of that ex parte protective order.
Do I need to go to court if I have been served a protective order?
The answer is yes and also no. If you do not want to contest the protective order, then you do not need to show up. However, if you do not show up, you're basically telling the court that you are submitting to this protective order. If it's already an ex parte order, meaning it's granted, and you fail to ask the court within 30 days for a hearing, that order is going to remain in effect. If the court sets a hearing for the protective order and you fail to appear to that hearing or don't ask the court for additional time to prepare your defense, then again, the judge is going to set a default judgment against you, meaning they're going to put that protective order in place. So while you don't need to show up to court, if you don't show up to court, that just means the protective order is going to remain in place.
What are the consequences of having a protective order granted against me?
Protective orders are civil in nature. So on its face, nothing criminal is going to happen if you are issued a protective order against you. However, once that protective order is in place, a lot of things can happen. It could limit your ability to access and own firearms. It could limit your ability to have parenting time if you're going through a custody or family law case when the other party is the one that you share the children in common with. The biggest thing that it can do, though, is it limits your access to contact a particular person or set of people. If you do contact those people after a protective order is in place, that's when things can change from civil to criminal, and that's what's called invasion of privacy. So if you have a protective order in place against someone and you talk to them, either in person or through texts, phone calls, Facebook, emails, anything like that, that other person could call the police and ask that criminal charges be placed against you. That would be invasion of privacy, which in Indiana is a Class A misdemeanor and carries a maximum penalty of 1 year in jail.
How long does a protective order stay in place in Indiana?
Again, that answer can vary. Typically, it is set in place for 2 years. After that 2 years has lapsed, the party that's asking for the protective order can ask to renew it, but it's not an automatic renewal. On the other hand, in some cases, if a judge thinks that the allegations are so egregious, the judge could make an indefinite protective order, meaning it's going to stay in place until the other party asks the judge to remove it.
Can I fight a protective order?
Yes, absolutely. Whether or not the judge sets a protective order for a hearing or grants it ex parte, you can absolutely fight it. If it's set for a hearing, you can hire an attorney, and that attorney can go with you to that hearing and assist in your defense by calling witnesses, presenting evidence, and trying to call out the petitioner for things that may or may not be truthful. On the other hand, if the judge issues an ex parte order for protection, meaning the order is already in place, an attorney can still fight for you. Now, that attorney can ask for a hearing on that protective order, and the judge must grant that as long as that request is made 30 days from the beginning of the issuance of that protective order. At a hearing like that, it's the same thing. Your attorney can call witnesses, present evidence, and cross-examine the petitioner or the petitioner's witnesses and ask the judge to rescind the protective order that was already put in place.
Do I need a lawyer if someone files a protective order against me?
The best answer is yes. Anytime you're dealing with judges, the court system, it's always imperative to have an attorney with you because that attorney is going to have relationships with the judges, the court staffs, and they know the ins and outs of the law because this is something they practice on a day-to-day basis. Even if the person asking for the protective order does not have an attorney assisting them, it's always in your best interest to have an attorney on your side. Because once these go to a hearing in front of the judge, it's going to be like a mini trial. So the person asking for the protective order is going to be under the same set of rules, laws, and regulations that an attorney would have, which means they have to follow certain rules of evidence. And if you have an attorney on your side, your attorney can poke holes, object, and do a lot of things that can kind of trip up the person that is asking for the protective order, especially if they don't have an attorney with them assisting them.
What evidence can I use to defend myself at a protective order hearing?
The evidence that you can use is going to be similar to evidence that you could use in a criminal trial if you're defending yourself as well. That can be eyewitness testimony. So if there was other people around during the allegations, we can call them as witnesses and have them testify on your behalf. Additionally, we could submit evidence on your behalf, whether that's phone call records, emails, text messages, photos. So there's many things that you can bring to the table to protect yourself against someone that's asking for a protective order against you.
What happens if I violate a protective order?
If you violate a protective order in Indiana, you're going to be hit with an invasion of privacy charge, and that's a criminal charge. It's an A misdemeanor in Indiana, carries a maximum penalty of 1 year in jail. And every time you violate that protective order can be a new invasion of privacy charge. So if you have a protective order in place against, say, your child's father, and you text that child's father 10 times, hypothetically, the state could charge you with 10 counts of invasion of privacy, each of those counts carrying a maximum of 1 year in jail.
Will a protective order show up on a background check in Indiana?
The answer is yes. If an employer, whether that's a future employer or someone that's just doing a routine background check when you're already employed, a protective order against you can show up on a background check and it can have negative consequences with your job. In Indiana, since we are an at-will state, if an employer sees something on your background check, even if it's not criminal, because protective orders are civil in nature, they can still use that to determine whether or not they want to hire you in the future or keep you retained as an employer. So it's very important that if you are served with a protective order, that you hire an attorney to fight that protective order, because even though it's civil and not criminal, it can have terrible implications on your personal life.
Can I be removed from my home if a protective order is granted?
The answer is sometimes yes. So if the person that's asking for the protective order lives with you and has a legal right to be at that house, then that can mean that the court could basically make it impossible for you to go back to the house if that person that's protected by the protective order is still currently residing there.
What if I didn't know about the protective order hearing?
In order to be properly served with the protective order, there are certain things that have to happen. Now, a protective order can be served numerous ways. A sheriff's deputy can come to your house and hand serve you the piece of paper that says there's a protective order filed against you, here's the hearing date, or there's been an ex parte protection order granted, here's the order for that. That's option number one. It can be personal service. What's more common is getting something in the mail via certified mail. That is another way to get service. So if you're living at an address and you get something in the mail, certified mail, and the court can kind of track it back to where you were living there at the time and you received it, then you're basically put on notice that there's a protective order that's either been asked to be granted and a hearing date's been set, or there's already been one granted ex parte. Now, if you're not hand-served and you don't live at an address that ever received any sort of mail, and sometimes that happens if the person asking for the protective order doesn't know where you live, then an attorney can argue that there's been improper service. And the way that that can work is if you don't show up to a hearing, or you don't, within 30 days, ask for a hearing, an attorney can kind of come in there and ask for that timeline to be set back because you didn't have proper service.
Can a protective order affect my firearm rights in Indiana?
Yes, absolutely. One of the biggest things when people are asking for protective orders is they ask the judge to prohibit that person from owning or possessing deadly weapons, which would include firearms and ammunition. If a protective order is granted against you, it's more than likely that you are not going to be able to have firearms. So it's very important that if you do have a protective order that's issued against you, that you hire an attorney right away so that we can protect your firearm rights.
How can I get a protective order dismissed or dropped?
Really, the only ways to get a protective order dismissed or dropped is if the person that's asking for the protective order goes to the court and says, I no longer want this, I want it dismissed. That's option one. The only other option that you might have is hiring an attorney to fight that protective order at a hearing, where the burden is going to be on the petitioner, the one that filed the protective order, to prove to the judge why they believe that they need to have a protective order against you. But again, at that hearing, an attorney can call witnesses, present evidence, and cross-examine the petitioner and the petitioner's witnesses to try to prove to the court that a protective order is not needed.
Can a protective order affect child custody and visitation?
Yes. When someone is filling out a protective order or petition for protective order, they can ask the court to limit parenting time. And if the court grants that, then it can make it hard for you to have parenting time, custody time, or anything involving the children in the future. And a lot of times you'll have to go to a family court to try to get that resolved. But yes, the absolute bottom line answer is a protective order filed against you can have significant implications on not only custody but parenting time with your children.
Can a protective order be used against me in a divorce or custody case?
Yes, absolutely. Especially if the person that's petitioning for the protective order is the mother or father of the children. Because what they will do is they're going to go to that family law court and basically use the allegations in the protective order to show to the judge why they are the person that should be having sole custody or the most parenting time. So it's absolutely important that if you're going through a custody or a divorce sort of hearing and you're hit with a protective order, that you fight that protective order because it could have serious negative implications in your family law case. Even though protective orders are civil in nature and not criminal, the implications can have dramatic impacts on your life and could lead to criminal charges if you don't abide by that protective order. So it's always important to have an attorney on your side. If you or someone you know are facing a protective order or have any questions regarding protective orders, restraining orders is what they're more commonly known as, but in Indiana they're called protective orders, please give us at the Marc Lopez Law Firm a phone call, 317-632-3642. And always remember, plead the fifth.